Yes, we've received an email from her indicating she wanted to set this over to next week.
Is Miss Mandy Gronitz present?
I'm not sure if she's on or not.
Yes. Can you hear me?
I can, yes.
Okay. Yes, Your Honor, I'm present. This is Mandy Gronitz.
Okay, and you are requesting a set over at this point, is that correct?
Actually, I just reviewed the file, and I could just make a quick change on my request, and we could settle the matter. Or we can set it over next week.
Okay.
But we are in communication. I have received new information, and we are communicating about that new information, and it does affect this case.
Okay.
My request is simply, instead of advancing me lawyer fees, that the petitioner pay the upcoming litigation expenses for the GAL and the motion to move. That's my request.
Your Honor, we're going to have to object to that. There's no motion for a GAL right now.
Well, in this case, they're requesting that I be denied to put in further motions, and I ask that that request be denied because I should maintain the ability to defend myself. I haven't even shown up to court on this case yet, and so I would like to retain the ability to show up to court. I am preparing motions. I do, however, have a really heavy caseload for pro se litigant. I'm in 4 different dockets. I have 4 different court dates just this week. I've been in 18 court dates in 9 weeks, and I have 200 different line items to process for those 4 dockets. So I'm handling a lot of information. They're all interconnected, and it keeps stalling. But the specific request for my litigation and my attorney fees, I can rescind that request. We can deal with this a different way, or we can set this over. I'm not sure the appropriate course of action. But I don't really want them to pay me. I want them to pay the litigation expenses coming up specifically, because that's what my request was kind of preparing for.
Okay, so
they have put in a motion to move,
okay,
and I will be
ma'am, when I start talking, you keep talking, and we need to not do that. So hold on a second. So today, the only thing that's on your cause number is a motion for advanced lawyer fees and costs. And so that's the only thing that it's on for today. So my understanding, I'm talking still. So my understanding is that you're not wanting for advanced lawyer fees. You're just wanting to move forward on the request for costs, as in if there's a GAL or something else upcoming. Is that correct?
Yes.
Okay. And I don't know, Ms. Hartman, if you are stepping in for Ms. Rush this afternoon and you expected it to be a set over, if you're able to deal with that, or if you would be still requesting a continuance.
So we're still going to request the continuance for next week. We had a written request, so we expected this to be a set over, and that's what I was prepared for. I believe Deanna would like to participate in this next week.
Okay. So next week, unfortunately, isn't going to work because, well, long story short, we don't have enough judicial officers to handle all the dockets. I have a doctor's appointment that's been scheduled for 2.5 months. That's next Tuesday at 2 p.m. So I shut the docket down at 6 matters, and I can't set it to next week. The week after that is already closed because we're maxed out at like 24 cases. So the next available date would be the 31st. Does that work for everyone at 1 p.m.?
That would work for us.
Ms. Gronitz, does that work for you?
I'm sorry, I was grabbing my account. November 30th?
No, October 31st. So 3 weeks from today.
Oh, sorry. Okay. Wrong month. So Halloween?
Yes, at 1 p.m.
Is there a penalty if I just rescind this and readdress it when we do the motion to move? Or I'm not sure how that works, but well, actually, that'll probably work over because we'll probably be dealing with the motion to move at the same time, so I can coordinate my paperwork to match that.
Well, and it sounds like if you're in communication with Ms. Rush, that's something that maybe you can discuss with her between now and the 31st. So I'll set it for review. I'll set it for review of your motion for attorney's fees for the 31st at 1. If you file another motion, it can get added to the 31st. Great. And we'll see what we have to work with on the 31st at 1 p.m.
Thank you.
All right. Thank you. I have as a show cause contempt, and there was some things filed, but nothing as of our last review on the 26th of September.
About right.
So where are we at?
So my understanding is we've been before the court. I think this is the third court hearing on my client's motion for contempt. Mr. Ibarra has appeared at every hearing. I don't know if he's here today, but every hearing he's appeared, he's indicated that he was seeking counsel. I think the last hearing he indicated that he was going to be making a payment to the babysitter in hopes to get current. I can report that has occurred. He has made some payments to the babysitter. The babysitter has been current. But to date, there's no filings, no attorney has appeared on his behalf. He's filed no formal response to my client's motion. Ultimately, my client was forced to bring this motion to get him to pay the, I think $1,400 that he was in outstanding childcare. We are asking still for a finding of contempt. Again, we had initially requested $750 in attorney's fees in our initial motion. Taking into consideration this is the third hearing on his request for setovers, I would ask that that be increased to $1,000 given the various hearings.
All right, thank you for that update. Does Shane Ibarra, are you present? *6 to unmute if you're on a telephone. All right, not hearing a response. I don't have anyone in my waiting room. In reviewing August 22nd and September 26th minutes, it appears that Ms. Bliss's rendition of events is accurate. We sent it over a couple times for an attorney. I know that that's been, I understand how difficult that is, but I also allowed him to serve upon the court and Ms. Bliss by email through today at essentially at noon, the information about being caught up. Is he ordered other payments besides the child care, Ms. Bliss, or is it just the child care?
He currently has a child support obligation and child care obligation. I think he was only behind in my motion. I believe he was only behind the child care, and he had got current on his, he became current, excuse me, on his child support obligation. I know my client reported as of yesterday that he is current in his child care, but now he is $3,700 behind in child support. So it seems that we're taking money from one obligation and putting it towards another and neglecting the other now.
All right, I do have a contempt order here. I will make a finding of contempt. He's not filed anything. What I'm doing is lining out the judgment for past due child support to 0 and indicating that that's been paid, eliminating the civil penalty, and I'm keeping a lawyer fee. I am going to leave it at $750. And I will sign and file that order.
Very good. Thank you, Judge.
Thank you. It's on for review.
Matter's ready, Judge.
So do we have Gary Rapp present? *6 to unmute if you're on a telephone.
Yes, Your Honor.
All right. So thank you. So we have Mr. Rapp here. We have, looks like a new MSC has been scheduled. Last time we were here, Ms. Bliss was covering for Mr. Zandy. Mr. Rapp was present, indicated he did jump through a whole bunch of hoops to try to log into the MSC, but wasn't able to. Said I would reserve on the judgment and told him to file proof that he attempted to attend the settlement conference. I haven't seen anything filed at this point. So Mr. Rapp, did you attempt to file anything in relation to that?
No, but I was out of town working.
Okay.
But I went in yesterday and made another $500 payment to Mr. Zandy.
Mr. Zandy, any position? It looks like it was Judge Warning that imposed the $500 in attorney's fees for non-appearance at the mandatory settlement conference.
Yeah, this is a case that we had actually been reset for mandatory settlement conference. It was initially scheduled to proceed in late June. my client was ready. I was ready. We submitted our materials, and a day or two beforehand, there was a commissioner shortage, so that got postponed. We immediately reset that for early September. And again, same process, submitted our materials, logged onto the computer. Thankfully, my client didn't drive up from Southern Oregon, but nonetheless, she made herself available. And we waited approximately 15 or 20 minutes. It became clear that Mr. Rapp was not going to present himself, and Commissioner Warning did, in fact, strike that settlement conference, awarded the $500 in fees, and essentially gave us the marching orders to set it for trial. So I got to my office about 45 minutes later. We did receive contact from Mr. Rapp indicating that he had tried to log on but was unsuccessful. I did not speak with him directly about that, but here we are. I would remind the court that this is set for a review of the maintenance payments today. This is a case where the order has been in effect since about this time last year. And to date, we have yet to receive a full payment under that temporary order. And my client continues to go backwards. Those efforts are frustrated then by the attempts to get this case resolved and settled. And we have various reasons why that hasn't happened. So that's first and foremost. I would simply ask, and I know it may be a little bit late in time to do this, and I appreciate Ms. Bliss appearing on my behalf last month. We need to get this done. My client needs some closure to this. If the parties can resolve the case informally, great. I would like to see this just be set for a half day or full day trial as opposed to going through the steps of a mediation, because that just, for whatever reason, doesn't seem like it's in the cards or meant to be, unfortunately. So leads me back to the, again, premise of the review today. We're again reviewing for I want to say 8th or 9th time, the status of the support payments. Traditionally, Mr. Rapp will wait until the last possible minute and drop a partial payment off to my office. Now, yesterday, he's correct. I did have discussed with him briefly in between appointments the situation related to the mediation as well as the status of the support payments. He did drop off $500. But again, that's a drop in the bucket compared to what is owed. By my count, we're now over $16,000 between outstanding alimony payments coupled with the prior attorney's fees that have been awarded, and the fact that we just can't seem to get into a settlement conference for various reasons. We have suggested, and I think given the circumstances, it makes sense. My client is literally spinning her wheels financially, having these review hearings in which we show up and say, Mr. Rapp's made partial payment. Sounds like a broken record. My client's going backwards under that scenario. What we suggested initially, and this was not before Your Honor, I believe this was Judge Scudder who heard the initial temporary order hearing. We had requested that whatever maintenance was ordered, and we now know that's that $1,200 per month. We had simply asked that that be taken directly from either one of the retirement accounts, and there's a Social Security, there's also a pension that he has access to, or, which probably makes more sense, that Social Security, which is direct deposit. The Social Security is $1,443 per month. I think we can resolve a lot of these issues. I mean, again, the maintenance is $1,250. If we just set up an account in my client's name, Mr. Rapp contacts Social Security Administration and say, this is the account that the award needs to go into every month. And we don't have to keep coming back every month on these reviews pending the time of trial or mediation or whatever way it is we go on that. That saves my client money. That saves both parties the need to keep coming back every month for these review hearings, and seems to make the most amount of sense. My initial request, the court had indicated last year, it was going to give Mr. Rapp the opportunity to make the payment and trust that he would do so. And here we are now 11 months later, and he hasn't made a single complete payment. I would suggest that the extra money, in addition to the $1,250 currently ordered, which again is going to be about $193, just be credited to the back amounts that are owed. And that gives my client at least somewhat of a basis, in addition to the $800 that she's getting per month in her own Social Security, to pay for her expenses. She has not been able to do that. She details for you in her declaration that she's relying off the gratuities of third parties down in Southern Oregon. She now has 2 grandkids, both teenagers, that are living with her, and she's not getting support for those kids. She is literally spinning her wheels, trying to not support herself, but these grandkids as well. She's in dire financial straits. I think the suggestion we have made makes sense and probably protects the interests. It also eliminates the need to keep coming back for these hearings as currently scheduled since last January.
All right. Thank you, Mr. Rapp. Did you hear all that?
Yes, I did. I'm on a fixed income. It's kind of hard for me to make that big of a payment.
What's your income on a monthly basis?
3,600 some. She has it. I know I make over $5,000 a month, and that's not right.
Well, I think Mr. Zandy's suggestion is not a bad one. You coming here every month is, well, or every few weeks, feels like it's monthly, is kind of a waste of everybody's time. And I don't, if you're making 3,600 a month and you're supposed to give her, I'm sorry, was it 12 or 14? 1,200?
1,250 a month is what's owed.
Okay, 1,250. And you're in arrears now close to or over $16,000. We got to figure something out that's going to fix this. Would you agree?
Well, I agree, but I'm trying to see if I can I want to find out what's going to happen so I can see if I can refinance and get a loan to get this taken care of.
All right. Well, at this point, I'm not going to change the ruling from Judge Warning, so that'll remain in place. And here's what I'm going to do. I don't know what your actions are or what you're trying to do to figure this out, Mr. Rapp. I'm going to set one final review, and if we don't have something sorted out, then I'm inclined to order what Mr. Zandy is suggesting to ensure that the payments that the court ordered a year ago are getting made moving forward until this case can be heard. And Mr. Zandy,
right,
if you are inclined to request the MSC be struck and get it set for a trial setting, I would be inclined to strongly consider that over waiting for this MSC, which it looks like it's not even scheduled until January now.
Correct.
Okay.
That was the earliest date I think we could get.
So I'm going to, Mr. Rapp, here's what I've given you a lot of leeway. I'm giving you a little bit more leeway, which I'm sure Mr. Zandy isn't very happy with. But we're going to review this on November 7th. That's a month from now. You need to figure out how you're going to make the payments that you need to make on a monthly basis, which is $1,250. Or else, if Mr. Zandy proposes what he proposed today and we don't have another plan in place, then I'm likely to strongly consider that, if not grant that.
well, my social security out of my pension.
It needs to come from somewhere. Mr. Zandy's suggestion is, I think, a valid one. If you have a better suggestion, then I think you need to propose it. And you can't just show up here and talk to us about it. You have to actually file something. And if you need to reach out to Mr. Zandy between now and then to come up with a plan, I highly recommend you do that.
I do have an appointment with Mr. Zandy next Friday.
Perfect. So hopefully there's a plan. If not, then, you know, a thing that you're going to probably expect to start happening come November is Social Security going to Ms. Rapp. Okay.
So do you want me to present an order on the 7th as well, Judge, with today's ruling?
Sure, assuming that you don't have, assuming you don't come to another agreement or Mr. Rapp doesn't have another alternative suggestion that would work for your client.
Okay, we'll keep that 7th date. I'll present an order at that time and we'll hopefully make some progress then.
Perfect. All right, we'll see you on the 7th. Good luck. Good afternoon, Miss Ward. Do we have, I see there's Mr. Couch. Few different issues. So I wasn't here the last review. My understanding is that Mr. Anagnostou agreed to step in, and we found out that there was a conflict there. We are on our 3rd county looking for counsel that will help step in for Mr. Couch. Then I was also notified that there was potentially a plan that would get the property out of foreclosure, and that if that plan was going to take place, we would know about it by today. So do we know where we're at?
I'm hoping Mr. Couch can answer it. He did submit a declaration in advance of the last hearing that said that he would have the property out of foreclosure within a week. That's why we set it over a week, to see if that was the case. I know the previous judicial officer had proposed a plan of having that money that was going to pay off the foreclosure put with the clerk or something to that effect. I had proposed that if Mr. Couch was in fact going to make that payment, that he simply go ahead and pay it, and that we set it over a week to have a status check and to ensure that that was done. I haven't personally received any updates. My client did actually, after the hearing, provide written authorization for the previous counsel to continue despite the conflict, just to move the case forward and stop having these delays. I didn't hear anything back from that. At this point, she's just incredibly frustrated. We're less than a month out from the trustee sale, and this motion has been pending since early July. So we've been coming back continuously for different hearings for the past 3 months. And she's just extremely concerned that we're about to lose the only major asset in this case to foreclosure.
I completely understand that, and I join in the frustration, probably from some different levels. But Mr. Couch, can you hear us?
Yeah, I can hear you.
Okay. Do you have an update for us?
Yes, Your Honor. I had an attorney for about a day, and then for some reason that wasn't approved by the petitioner. So it just is tied my hands here, because with this pending, I have the ability to borrow the money to make it up, but there's no way in good faith I can do that with that lender, when this could potentially just be taken out of my hands. This doesn't make any sense to me, because there's no time for them to take the property from me and turn around and sell it in 2 weeks. The money's got to be paid by the 23rd.
So Mr. Couch,
so it's kind of a standoff.
Mr. Couch, the question is, did you find a way to pay off the money so the house or the property isn't going into foreclosure? Yes or no?
Yes.
Do you have proof of that?
Well, I could get proof of it, but it's kind of a standoff, because I can't get the money until they remove this, whatever it's called,
there's nothing.
I'm supposed to have an attorney here, and I don't, but it seems like.
I understand that,
Mr.
Couch. Here's where I'm at. You had an attorney last week, Mr. Anagnostou. It was brought up that Mr. Anagnostou previously consulted with Ms. Couch, which is a conflict of interest. It sounds like she was trying to waive that conflict of interest. Unfortunately, that may have occurred too late. So Mr. Anagnostou was relieved of his duties based on that conflict that was raised by the petitioner. It wasn't because the petitioner didn't want you to have an attorney, as far as I know. It was because my recollection is that I believe that Ms. Couch maybe consulted with Mr. Anagnostou at the beginning of the dissolution process in this case. Okay. So that is a genuine conflict. However, on that date, while you were represented, it was relayed to the court and to opposing counsel that there was a plan that could be refinanced within the week, and that they would withdraw their motion for the sale of the property if it could be refinanced and taken out of foreclosure.
I got nothing in writing on that, Your Honor. That I was, as soon as that hearing started, then Ms. Ward indicated that we can't have this attorney. And then she said, well, we can have it. But then the judge said no, because if you don't allow Mr. Anagnostou to represent Mr. Couch the whole time, then he can't represent him here. But then they went on to start talking back and forth. There was no request for me to get proof of what you're saying now, Ms. Ward's saying, now, oh, there, like there's no proof of that, but I never got anything in writing that said anything to the fact that if I was able to get the money that they would drop this. It's kind of like the chicken or the egg. What's going to come first? I'm saying, please drop this because, deny this, the motion they have, because it makes no sense because there's no time for them to take it back, put it on the market and sell it to meet the deadline, but it's holding me up because I'm not able
it's absolutely not holding you up. It's absolutely not holding you up. There's no way that this motion would bar you from refinancing and getting that property out of foreclosure. So, and anything in writing would be great because you've never filed anything in writing as far as this is concerned. I understand you're in a position right now where you are entitled to an attorney. We are continually looking for that attorney. But what's going to happen now is your property is going to go into foreclosure and then everybody's going to be lost on everything if you don't act. You're the only one that can do something here. And to be very frank, I don't know that if I granted this motion, that the people doing the foreclosure wouldn't wait and allow them to try to sell the property first. I don't know that. So we're kind of in a position where, frankly, you need to be the first actor. And you say you don't have anything in writing. Well, it's part of the court record that Ms. Ward indicated that they would dismiss the motion if you found a way to get the property out of foreclosure. So that's where we're at. We don't have an attorney for you yet. We're still looking. We're waiting for a call back from another attorney that popped up locally, but we're currently looking in Lewis County and Clark County to try to find an attorney for you. But there's nothing that says you cannot refinance and get this out of foreclosure because this motion is pending. And if you don't do that, then everybody's going to lose because February 3rd or November 3rd is quickly approaching.
Yes, Your Honor.
So yeah, I don't, and I wasn't here last week, but I spoke with Judge Scudder. I reviewed the minutes. So Ms. Ward, if there's anything else.
I feel like maybe there's some sort of fundamental misunderstanding with Mr. Couch. Just one thing to clarify is that his counsel did file pleadings in advance of the last hearing. And in those written pleadings, they stated that Mr. Couch was going to get the property out of foreclosure within the week. That is why we agreed to a set over, and the payment is the proof, right? When he makes the payment, we will know that he made the payment and got the property out of foreclosure. So we're not looking for any kind of written proof. We just want him to make the payment and we will drop the motion. And I feel like Mr. Couch isn't understanding that. The whole reason this motion is pending is because he hasn't gotten the property out of foreclosure. We want to make sure that if the property is going to be sold, it's not for a bargain basement price at an auction, at a foreclosure auction. That is the whole reason this is pending. And it just feels like a broken record. Every single time we come here, there are more excuses and more delays. This has been pending for quite some time. My client is taking a hit by even agreeing to dismiss the motion because, quite frankly, she should be entitled to attorney fees given the ongoing delays. Mr. Couch should have been acting to get this property paid consistently before it even went into foreclosure. It has been months and months and months since he's been on notice that he was going to lose this property. And yet every time we come, he's asking for more time to accomplish something to get it out of foreclosure, though it's never been clear what that plan is. So at this point, we are asking, he had an attorney represent him, file pleadings on his behalf. In those pleadings, they state he will get the property out of foreclosure within the week. He has not honored that. At this point in time, we are asking that the motion be granted, that any contracts he's entered into since this motion has been pending be set aside, but that be added to our proposed order, and that we be allowed to list it immediately to see if we can get it sold prior to the foreclosure. Because the reality is, if it goes to foreclosure on November 3rd, there's not going to be any equity in it whatsoever for anyone.
Ms. Ward, you indicated that your client, did she file a written waiver of conflict?
No, I emailed counsel after the fact. As soon as he emailed me a copy of his motion to be released from the case, I replied back and said that she'd be willing to waive the conflict if it meant that the case could continue to move forward so that there were no more delays. And I didn't receive anything back. I also don't know the status of the motions and orders that he filed. I didn't get a filed copy of anything. All I saw were his proposed drafts.
Would you be willing to send that to me as well? And the reason why is the judicial assistant that we have that works with the attorneys, if she reached out to Mr. Anagnostou saying, hey, they're waiving this, can you, I'd be, I understand your position. I understand we're in a mess. Mr. Couch, do you understand that kind of the severity of the situation that we're in here now?
I absolutely do, Your Honor.
And do you understand that you're the only one that didn't do anything about it?
Yes, I'm trying my best, Your Honor.
So the last week, what have you done?
Last week, I've tried to coordinate getting this done, but I have no communications. Ms. Ward said that she sent that. I never got anything to state what you just were talking about. And
I replied all to the email from his attorney.
Okay, Your Honor, this is what I'm talking about. Like, Miss Ward just tries to walk over me and bully me, doesn't let me talk, and goes on, and I get to talk for like 20 seconds and I get cut off. And this is part of the whole problem. There's no negotiation. I'm trying to do the best thing for my family. My kids are involved in this as well as myself. It makes no sense to come back on this to try to take this property over when I'm the one in the best position to make it happen. They have no plan on their side. They just say, oh, we want the property. How within that short amount of time then are they going to get the money? And yeah, maybe there's possibly that the lender would give them time, but they're not communicating with me on that. I mean, we should be working together to prevent this, not holding me over a fire I have to do it with this looming over me. And then I finally get an attorney and then they smash him for nothing. That was not to do with this dissolution, Your Honor. That was in 2018 when the petitioner filed for a legal separation. Okay. And it had nothing to do with this case. And Mr. Agnostou doesn't remember it. There's no recording. There's no receipts. The petitioner said that she paid cash. I mean, it's at this point, why can't we just work it out? I don't understand it. It's just, I'm the bad guy here. And I've been trying my hardest. But now, right now, it's like, and each week, if you understand, we say, okay, now we got a week or 2 weeks. It's like having a weight on me. It's hard for me to even function, but I've been able to, coordinate it to where if this will go away, I can get, the funds to get it out of foreclosure. But I know you're saying that it has nothing to do with it, but it has a lot, because you can't borrow that much money from friends and family and then have it taken away. Because this is like unclear. I can't equivocally say to them, yeah, okay, loan the money and your money's secure here, because the petitioner might get this motion to go through. And then I'm literally have to move out. I have no place to go. My children are out of a place of their income. And it's just, it makes no sense why they're doing this. It just seems more like retribution or something like that, because if they can answer how they plan on selling this place in, less than a month, and I would like to know that. I mean, I would like to be involved in that. Do they have a buyer already? Because the company that
Mr. Couch, we're getting a little far afield at this point. If we're going to get down to like the brass tacks, you are so far in arrears on family support. This is the only asset that's left. That's why that's where the concern comes from. You're the one who has the keys to that building, so to speak, literally and figuratively. However, those keys are going to get snatched away from you and no one's going to have anything. So to me, this has been 3 months almost in the making, that we're here. Now we're less than a month away from this foreclosure. There would be no grounds for me to order the sale of this property, if it wasn't in foreclosure. You're not going to get anything in writing from the court. You're probably not going to get anything in writing from Ms. Ward, but that's been stated on more than one occasion. I can understand them. They're not going to dismiss that until it's out of foreclosure. So that's where we're at. So you can either fix this problem by paying off the money, getting the property out of foreclosure, or we'll see if we can get Mr. Anagnostou back. And frankly, in his filings with the court, he told the court in the documents that you filed and signed with him that you were going to do this by today's date, and you haven't done it. So, but you're not represented, and you currently need to be represented. And it's a difficult situation to be in because we're now really under the wire. So I don't know how to stress that you're the only one that can control the outcome of this. Otherwise, everybody loses. And I know you've stated multiple times that this involves your entire family, and I don't doubt that. I don't disagree with that, and I'd love to think that you are considering the best interests of everyone. But you do have the mother of your children and another child that their payments have not been made to them. So they're trying to protect something that is potentially worth something. So I did reach out to my administrative deputy. She's going to reach out to Mr. Anagnostou to see if he can step back in on this case. And my hope is that he will with that waiver. So if you could just, Ms. Ward, I know you indicated you sent it to all the parties. If you could just send it to Superior Court Administration so we have that. And if I'm going to set it over one more week to the 17th at 1. I know I closed that docket. If we could add this onto there. And the decision is going to be made by the 17th because we're in a position there. I can only guess. I don't know if the people that have it in foreclosure are willing to give additional time if the property is put up for sale. I don't know the answer to that. Mr. Couch, if you want to contact Miss Autumn Terry, I know you've gotten acquainted with her recently because she's been working on trying to get you counsel, but she's reaching out. She just sent me a email that she's reaching out to Mr. Anagnostou. So if you want to call her later today or first thing in the morning and see where we're at there. And there was one other attorney that was looking at their books to see if they could potentially step in. So reach out please to Miss Terry in the morning, and we'll review this on the 17th at 1, but we're getting down to everything's in the red now. So we are frankly nervous for the entire family here in this situation. So I hope, Mr. Couch, you figure out what you're going to do with this in the next week.
Yeah, thank you, Your Honor. It's difficult because, I'm at a big disadvantage here. And so me trying to explain or articulate what's going on is very difficult for me. And Your Honor, Mr. Anagnostou was, willing to take the case. And then if I can understand. So Miss Ward has said that she sent something to Mr. Anagnostou that said that he can represent me. Is that correct? Because she was saying just for this day, but there's a big difference. There's then one day he didn't even have time.
Mr. Couch,
no.
I can't keep going on this, but yes, she's said that there's been essentially a waiver by Miss Couch that she waives any conflict and that Mr. Anagnostou could represent you in this matter.
Okay, that's great. Thank you, Your Honor. That I wish I would have known that.
Well,
Your Honor,
we didn't know that. I don't know if we knew that then, and I don't know if that's yes, Miss Ward. Go ahead.
I just want to point out, I hate to interrupt. Sometimes it's very hard for me to have an opportunity to respond. I did reply immediately when his attorney sent out his notice of intent to withdraw that my client would be willing to waive what is a valid conflict on her part simply to move this forward and get this done. It looks like Kay Looney and Jay Wright with Cowlitz were both CC'd on that original email that I sent. I just forwarded it to the same individuals along with Superior Court as requested. And I just got a confirmation from Autumn Terry that was received. I just want to reiterate for Mr. Couch that the only reason this motion is pending is because we don't want it to go into foreclosure. If he pays the amount that is owed, we will voluntarily dismiss this motion. However, if we appear again in 1 week, and it has now been 2 weeks since he said he was going to take the property out of foreclosure, we will be asking that Your Honor grant our relief and set aside any contracts or other leases he's entered into while this motion has been pending, since it is only further encumbering the property without the authorization of the trustee. That's it.
Okay. All right. So, Mr. Couch, reach out to Ms. Terry in the morning and the 17th at 1 p.m.
4908.
Thank you, Your Honor.
I do represent the petitioner, Rebecca Rodriguez. We are here on my client's motion for default. Mr. Rodriguez was served in Florida on June 16th of this year, and we are currently at the 116th day, and there has been no response filed to the petition. I have provided to the court an order on the motion for default. I did check Odyssey today. I don't see anything that has been filed by him. I have not received any response to the petition. My client and this child are entitled to some finality, so we're asking the court to grant the order as presented.
There was one response filed 9/11/23. Declaration of respondent in response to petitioner's motion for temporary family law order. But that's for the entire response to the entire dissolution. Is that what you're not having or receiving?
Yes, I have not received a response to the petition, so I don't know what issues are in controversy. Clearly the summons outlines that, and my motion that he's had now for 3 weeks outlines that. We did provide him notice, and it appears that he is on Zoom. So.
All right. Is Emmanuel Rodriguez Stisser present?
Yes, Your Honor, I am.
All right. And you understand the request, and did you receive the motion? It looks like there was service. The
original service on the petition was June 16 of 23, and then the service on this motion was September 18th of 23.
Thank you. And I don't see any response. So were you intending to respond?
Actually, Your Honor, I'm not really, I have this motion you're talking about. I just don't know what it is. I don't really understand how I'm supposed to respond or what to say, or I don't even really know what it is. I'm completely confused. I'm over encumbered by all these documents and things coming at me and things I'm supposed to reply to, but I have no idea what I'm replying to. Yeah, that's it.
We would simply ask the court to grant the relief requested. I mean, this case has been replete with lack of substantive responses to motions and the action that's before the court. He's had 3 weeks, at least for purposes of this motion, to take some affirmative action, and he's failed to do anything.
Did we hear this case a couple weeks ago, right? And the parties worked together for visitation, and
yes.
We have a recently imposed temporary family law order and parenting plan.
Correct.
Okay. All right. So, Mr. Rodriguez-Stisser, I unfortunately am in a position where I cannot give you any legal advice. I can recommend that you seek out legal advice in this case. There was a properly served petition. Get back there here. Petition for dissolution, proposed parenting plan, motion for temporary orders. All of that were served on you, I believe, while you were still residing in the state of Florida. the summons and notice about the marriage and domestic partnership, the petition for dissolution, declaration about public assistance, notice of military dependency, notice of unavailability, declaration of personal service, motion and affidavit, notice of disqualification, family law calendar notice, motion for temporary family law order, declaration of petitioner regarding motion for temporary orders, proposed parenting plan, financial declaration, child support worksheets, and sealed financial documents, along with proposed temporary family law orders, parenting plans, child support orders, and child support worksheets, all the way back on the 16th of June of 2023. There's been no response to that petition at this point. You have appeared in court at least once, and we got some temporary orders entered. A default at this point doesn't change those orders or do anything to those orders, but with no response filed, I'm going to recommend that you seek out assistance of counsel. And as I stated, this doesn't change the temporary orders, but I am going to grant the default given that there's nothing filed and no formal response to any of those documents that I just listed off.
We will provide Mr. Rodriguez with a conformed copy of that order once it hits Odyssey.
And that matter's ready.
All right, thank you.
Thank you.
Right. And Mr. Hoffman is present. I'm assuming you are Gene Hoffman, is that correct?
That is correct, yes.
Okay, thank you. All right, and then we're on for a motion hearing regarding specifically, excuse me, adding some additional language in the parenting plan regarding extracurricular activities, specifically some sports. Is that correct?
That is correct, Your Honor.
All right, I have reviewed the motion and the declarations, the reply declarations. Any additional comments or argument?
Your Honor, just briefly, I understand that you've read all of the materials and there's quite a bit, especially with my client's reply declaration. I just want to stress for the court that my client's request is reasonable. She's simply asking that the children be permitted to engage in extracurricular activities and that both parties be required to take said children to said activities. I understand in Mr. Hoffman's responsive declaration, he went at lengths at villainizing my client and attacking her character and attacking her reasoning for wanting to do this. But I think the facts of the matter are clear. My client doesn't have any basis to control the scheduling of practices and games. And it is unfortunately, or fortunately, depending on how you're looking at it, the responsibility of the parents to ensure that the children are actively able to engage in activities that they're specifically requesting. My client provides that the youngest child, Keegan, has expressed an interest in wanting to do football. It's been recommended by his counselor that he do football. My client enrolled the child in football, and then father essentially said, either you provide 100% of the transportation or they can't go during my time. Alternatively, he's taken to the position of just foregoing his residential time because he chooses not to take the children to and from their activities on the weekends. And this is causing significant conflict for not only my client, but the children especially. So we're simply just asking that very minimal language be included that includes the ability for the children to participate in these activities and require both parents to ensure that the children are attending these activities.
Great, thank you. Mr. Hoffman.
So I would disagree with that. I actually am not trying to villainize Ms. Manser whatsoever. I'm just trying to point out that this needs to be a joint effort as we are trying to co-parent, not have Ms. Manser make unilateral decision as to what she wants to sign them up for, what she doesn't, especially on my time. Even though my time is already limited, she's just becoming very controlling, overbearing, and despite temporary court orders, she fails to respect them. I mean, every email that is sent, it's always, I've signed them up and you need to take them. It's never, hey, can we just discuss this? Are you able to make them? And, you know, I have limited time with them. So I'm trying to also spend time with them, whether it's go camping, take them on a trip, go somewhere. And this actually prohibits that because Ms. Manser will sign them up and either I have to forego my time or I have to travel 45 minutes each way, you know, go back and forth and, you know, basically do what she wants me to do. And it's just, I think it's very unilateral and very one-sided and very controlling.
I'm assuming you reside outside of Cowles County, is that correct?
I do, I reside in Vancouver, yeah.
Okay, I thought I read that.
And then can I get a chance to respond to her motion?
That's what you're doing right now. So it's
no, to the one that she filed in response to mine.
Oh, her reply declaration.
Yeah.
Yeah. Go ahead.
Oh, can I submit like evidence or?
We're at the point where I'm going to make a decision, so it's probably too late for that. I don't know if, I guess, what type of information were you wanting to submit as evidence?
I just wanted to submit just in all the wording and stuff that she didn't necessarily put in the full picture. She just kind of pieced together emails and conversations. Mm-hmm. There's also video evidence of the interaction between both of us, and just to show like the true nature of what's actually happening and who's trying to co-parent and who's not.
Okay. I don't know, this is going to sound callous and I don't mean it this way. I don't know that I would necessarily put a lot of weight into that at this point. But I appreciate you raising that. Ms. Bliss, this was your motion. Any additional comments?
Your Honor, I think my pleadings speak for themselves. Obviously, what's in the children's best interest is that they be allowed to engage in the activities that bring them joy. And that's what my client's asking for today.
All right. One thing I did notice is that, frankly, I'm siding with Mr. Hoffman on is Ms. Manser seems to dictate what they're going to be doing and when they're going to be doing it. I understand she doesn't have any control over when practices are, when games are. Clearly, that's obvious and that's out of her control, and I understand that. I also understand Dad has limited time. I think parenting plan is every other weekend. Is that correct? So this arguably could be a large, for lack of a better term, time suck for him. And I didn't, in reading all the declarations, didn't necessarily see it as him not wanting to participate with the kids and these functions, but just being told, oh, this is what they're doing now and you have to do it, is part of the issue. And frankly, she doesn't seem to be including him in those decisions, which frankly, I understand the frustration there, especially when you're looking at, 2 to maybe 3 weekends a month with your children. What I'd like to do, and I have proposed language from both of you. I do have an order on hearing, a hard copy in front of me from Ms. Bliss. I think we're in the middle of, I'm sorry, one of them's playing football and one of them's playing something else right now. Is that correct? Or is it just football? Right
just my youngest does football right now.
Okay. And the oldest isn't doing any sports at the current time.
Correct.
Okay. Here's what I'd like to do. And I don't know if I may be able to change this order a little bit to fit what I'm going to. The temporary parenting plan does not list extracurricular activities. It was entered a year and a half, well, not maybe quite a year and a half ago, last summer. And it doesn't contemplate anything other than, hold on, I have it right here, from July of 2022, talks about school, education, and healthcare. And those are all joint decisions, or we're left as joint decision makings. There's no 191 factors in this case that have been founded. I don't know if any were alleged. So I'm going to include now extracurricular sporting activities. I'd like that to be included. I'm going to try to write this down while I'm extracurricular activities in sports as a joint decision making. I think we need to, what I can say that is very clear, at least in my opinion, from reading the declarations and kind of reviewing some of the information that set the parenting plan, as I think both of these parties do want what's best for their children. And I have no doubt about that. I don't know that, I don't think that Mrs. Manser was being, malicious or doing anything when signing her kids up for this. But I think, and I also understand that it wasn't specifically outlined as a joint decision. I'm going to make it a joint decision. That way, Mr. Hoffman does have some input into that. If there's a certain season or certain activities or certain, every April we go camping in Montana, whatever it is, that the parties are aware that they can work together, and that, you know, maybe that weekend there's no baseball, or maybe that weekend there's no whatever it is. But I do think extracurricular activities and sports should be a joint decision making. I do think that if that's something that one thing Mr. Hoffman pointed out, and I don't know, I don't recall it specifically in the response, was some of the counseling or recommendations that one of the children participate in a group activity sport. Having Mr. Hoffman have knowledge of that, since everybody is joint decision making. So hopefully he would have access to that information, knowledge of that information, and they can agree to some of these things. But I want him to be extracurricular activities and sports to be a joint decision making, and that activities that fall on either parent's weekend that they provide transportation. If there is a pre-planned trip function that excludes the child from a practice, a game that falls on a weekend, that needs to be disclosed as quickly as possible. So my hope would be that there isn't a last minute, okay, we're going to go to the beach for the day, because that's easier than going to these 2 football games. I would hope that there can be some, they're in the sport now. Let's let them finish the season as much as they can without interruption. And then every sport moving forward will need to be a joint decision. Does that make sense?
It does, Your Honor.
And Your Honor, my client addressed a lot of that in her reply declaration. You may have seen that the issue had become Mr. Hoffman just simply failing to respond to any correspondence from my client, blocking her on numerous accounts, just not responding. And so I know that that's going to continue to be an issue unless there's some language in there that specifically says that if there is an agreement or disagreement, it needs to be disclosed within a reasonable amount of time. Like agreement shall not be unreasonably withheld. I foresee that being an issue as well. So those would be my requests. I'll, obviously make my pitch to the court and you can make that decision. But I just foresee a lot of us coming back to court every sports season because this is going to be an issue.
I actually proposed in my response that there needs to be a 24-hour response time that I believe Ms. Mansard just did not even address.
24 hours is perfect.
All right, so I'll adopt that 24-hour response time. So again, I understand that it's sometimes difficult to continue to work with people that you're no longer in a relationship with, but you do have children in common that need the best of both of you, and that requires you to work together as much as that may be difficult. So I think a 24-hour response time. And that kind of goes along with any agreements shouldn't be unreasonably withheld. That for the remainder of this football season, I don't know how much longer this goes, but unless there's a pre-planned event, which you let the other parent know about as far in advance as you can, that the activities, at least of this season, continue. And the parent, if it's on your weekend, you provide transportation. And moving forward, extracurricular activities and sports would be joint decision-making.
And then, Your Honor, can I ask for the $1,500 to be paid by the petitioner, as I had to, obtain assistance for the response and find new counsel in the meantime?
I'm not going to award any attorney's fees in this case.
Okay.
For either party. I do believe that I can probably modify your order. There's probably going to be a fair amount of whiteout on it, but I think I can modify it so you don't have to refile it. And just so we're clear, it's going to read that the parenting plan will also include major decisions for extracurricular activities and sports to be joint, that if they fall on the parent's weekend, that parent will provide transportation, any conflicts notified as far in advance as possible, and that there's a 24-hour response time to any proposals for those activities. Sound good?
Thank you, Judge.
Okay, I will get that filed this afternoon. You should be able to get copies of it off Odyssey within the next couple days.
This is Andrea Poplawski appearing on behalf of Mr.
Thank
Brown. Mr. Brown is also present via Zoom.
Perfect.
Day guardian ad litem also present.
All right. Good afternoon, everyone. I have I've reviewed everything, and I am happy to hear a brief argument from both parties. And then I'm going to, Ms. Day, just so you know, if you, I'll give you an opportunity to weigh in on anything before I move to my ruling.
Could I just bring up one housekeeping issue first?
Sure.
On there was a Exhibit 3 attached to Mr. Brown's declaration that was filed back on or about I think it was August 4th. Oh wait, no, I'm sorry. It's the one that was filed on or about September 5th. It says it's identified as strict reply declaration of Alan Brown. I apologize, I didn't look up the clerk's paper number, but if you look at Exhibit 3, that is the documentation from DCS in regards to child support, and it has social security numbers and a D number, which is the interoffice number for DCS, and those are private identifiers. I'm asking that document, Exhibit 3, be removed from the court public file and filed under sealed financial source documents.
I don't have a problem with that, Your Honor. Sorry for the mistake on that.
Okay, sounds like if there's an agreement, and I do see it's index number 62, Ms. Poplawski, in Odyssey, and it does have a 9/5/23 date on it, and it's Exhibit 3. So starts on page 13 of 25.
And Your Honor, I was also going to just indicate, I know when we were here the last time, the court had set it over because of the reunification evaluator, and hope that we can have that information so the court could make a more informed decision. And I think it might make sense for the guardian ad litem maybe to talk first and to provide a summary of the information. I'm not sure if it made it into the file because we just recently got a letter from the evaluator, and maybe that information can come through the guardian ad litem first, and then the court can let us know where it wants to go relative to that as a backdrop.
Any position on that, Ms. McLean?
I don't have any objection to that proposal, but before we move on from your order relative to Exhibit 3, I just want to make sure that counsel, one of us needs to prepare an order to have that removed from the clerk's file and then refiled under seal.
Could do that.
Okay, thanks.
I will say that I did not, and let me just double check there. Sometimes things appear in Odyssey the day of the hearing that weren't there when I reviewed. And I do see that today there is now a 3-page, well, to 2-page letter from, looks like Ms. Rosen, and that wasn't there when I reviewed. So shouldn't take me more than a minute or two to review this. So just 1 second. Ms. Day, do you want to, I guess, kick us off?
Yes, Your Honor, thank you. And just so that you know, I did provide that letter as soon as I received it, and I dropped a courtesy copy off for you yesterday, and I'm not sure why it didn't make it to you, but we might need to look at that, but I'm glad you had a chance to read it. I did have a chance to talk with Charlotte Rosen and share some of the information that I had. And I do think that we are in a place now to begin that process of starting those transitional visits. I think that her recommendation to have 2 or 3 visits with Ms. Anderson, which is Lauren's regular counselor that she sees on a regular basis, 2 or 3 sessions to occur over the course of the next couple of weeks, and then to begin the visitation supervised therapeutically at Charlotte Rosen's office and start that process. I think that absent that, there's no other good way to get off of where we are now. There is no ongoing investigation at this time. There's no plans for a second CJAC interview. I agree that the allegations that are made are very concerning, and I don't doubt that they are not without grave concern. I know for Mother, and certainly for everybody involved in this case, but by the same token, we are in a position where we have to move forward in some manner. Father is adamant that he has not committed these acts or done anything that was even close to these acts. I think there's understandably his frustration in not having contact. By all accounts, and in Ms. Rosen's letter, The relationship between Dad and Lauren was healthy and strong and very bonded prior to this. And I think that the only way that we can move forward is to start to move forward slowly, safely, and protectively. And if issues arise, Ms. Rosen is there to help and to inform the court and myself, and steps can be taken if necessary.
May I ask Ms. Day a question?
Yes.
Ms. Day, last time we were here, you had also outlined a request, at least at that time, that there be no further contact or visitation until Mr. Brown had completed a psychosexual evaluation, because at least from what you had indicated, you don't know where the truth lies, and that would provide you additional information as to whether or not he was being truthful in his representations. Are you still making the recommendation that he participate in that psychosexual evaluation?
I think that's something I will potentially include in my report when I write my report, but the court had already ruled on that, so I didn't feel like I was appropriate to bring that forward again today. That was my request last time we were here, trying to find a solution to where we are. And the recommendation was to do this evaluation for the family assessment. I think that was an appropriate one. So I think that we're in a situation now to move forward with that. I will continue my investigation and try to observe those visits and then write a report and see if that's appropriate to continue with that concern and raise that then.
And I guess my only input relative to that is that I understood that the court was reserving that for further determination and argument today, and also to discuss costs. Let me go back to my notes.
And Your Honor, my understanding was that the court was not going to rule on that the court wanted to have this matter set over to a reunification evaluator to make a determination how we should go forward. Also with the ability for that individual to suggest if they felt that prior to going forward, they needed information from a psychosexual evaluation. And there's nothing at all indicating from Ms. Rosen that that would be appropriate. I think, as the guardian ad litem has stated, we're trying to figure out how do we move forward. The evaluator has already spoken and has given us a very, very detailed, a very cautious, a very meticulous roadmap on how to do that. I think that makes the most sense for us at this time. Everyone has agreed that previously Dad has had a great relationship with the child, a bond with this child. Mom even told the evaluator that, even though in her declarations to this court, she said something different. And we just really need to move forward on this. CPS is closed. There's no more CJAC evaluations. The police investigation there's no intent to move forward. I think it needs to just stay as is for a statute of limitations issue. The guardian ad litem will probably speak more about that, but I know she has confirmed with the investigator that they are taking no action on this. My client did the polygraph test, which proved he was truthful.
And again, I would object as to any discussion about a polygraph. That's not properly before the court. Counsel is well aware of the case law that I've already outlined, and that's not definitive of controverted facts that are before the court.
I think the guardian ad litem has known about this, and that's part of her investigation and part of information that would provide the ability for us to move forward. I think that's where we need to go at this point. So we would be asking that the court not order that let's just start moving towards getting this relationship back on track with all of the appropriate safeguards in place.
And I'll just note, and this I probably will take, probably speaking for Ms. McLean a little bit on this, but my notes in the minutes indicate that the restraining order, parenting plan, and request for psychosexual evaluations were set over to today's date for additional consideration. So I think it's still on the table. Arguably, I know that, well, I'm not going to speak for Ms. McLean any further, but I don't know if that's still a request. And I guess I would ask a follow-up of Ms. Day if it sounds to me, based on Ms. Rosen's letter, that even without that, they're willing to move forward at this point, and with essentially the plan that they've outlined with the counseling visits and then supervised visits and continued counseling. Is that fair?
That is fair. And that was my understanding. When I discussed with Ms. Rosen that I had made the request for a psychosexual and my reasoning for that, and I apologize, I understood that was not happening. So if the court wishes to make that decision, then I think that would be great. I don't think that that's an inappropriate request given the allegations that we have here in this case. Ms. Rosen didn't feel like she could speak to that specifically based on the evaluations that she had done already and the status of things, because she'd only met with the parents. She hadn't observed any visitation or contact. So she wasn't going to give input on that specifically, but based on the information, this was her recommendation for moving forward.
Okay. Okay. Ms. McLean, any additional questions for Ms. Day?
So I guess last time we were here, my understanding of Ms. Day's recommendation was that there should be no contact, that they were still that the child was still completing the sexual assault therapy with Ms. Anderson, that there is a future CJAC sometime anticipated to take place, that the criminal case with KPD is, while it's inactive, it is still on hold. Statute of limitations runs years after this child turns 18. So that's sort of a red herring. And then the request for the psychosex evaluation, again, when we have facts that have come before the court coupled with the sexually charged behavior by the child that has been observed, and the two different disclosures by this child to, actually, I think there's been 3 disclosures to 2 different counselors, that in and of itself warrants us having a further evaluation of Mr. Brown to hopefully provide some further feedback to this court on what's going to be in the best interest of this child. I think, obviously, speaking on behalf of my client, the concern is placing a 6-year-old back in, albeit a therapeutic supervised visitation location, but with a father who is accused of having sexually abused this child before the father addresses those underlying issues. It just smacks of putting the cart before the horse. We have a potential perpetrator, an alleged perpetrator, who has done nothing as far as any type of services to correct that behavior. And so, I mean, if we were looking at somebody who is addicted to drugs, we would require and mandate that there be evidence that they were no longer under the influence before they started participating in those supervised visits with the child. Similar here. Is that
asked if there was questions for the guardian ad litem. If we're making an argument, I believe it was my client's motion, and the motion was just to do the visits, to start supervised visits again. I believe that when we were here last, part of the guardian ad litem's recommendation was suggesting the psychosexual evaluation. This wasn't a motion, that was a formal motion brought by Ms. Teethers. And that was specifically because to find out whether there is an issue or not. And then the court recommended the evaluation to be done, and that was done. And we have the information as to going forward. And certainly if Ms. Rosen wants to put something in a report or makes a further suggestion on how things should go, but this was my client's original motion regarding the visits and a restraining order. I don't believe that Ms. Teethers had a motion, and the psychosexual came up at the hearing we were here last, just as a suggestion by the guardian ad litem. And I believe Ms. Teethers, Ms. McLean, just kind of ran with it and is now making this the primary issue. And so my understanding just originally was this court said to Ms. McLean, do you have any more questions of the GAL? And now we're getting into formal argument, trying to force this issue of the psychosexual evaluation. And I think it's really an attempt to delay the moving forward of the reunification as suggested by Ms. Rosen.
I note that. I did ask if there was any further questions. I understand. I don't know if you were trying to get to a question, and if sounds like Ms. Day, Ms. McLean may want to know if your recommendation is to go with Ms. Rosen's recommendation or to stick with your initial no contact because things are still moving forward in the criminal.
So my recommendation today is to move forward with Ms. Rosen's suggestion on how to move forward. The criminal matter is dormant. There is no activity or action happening there. I've spoken with the detective and I followed up with them. There is no CJAC scheduled, and I know Ms. McLean said when we were last here that the child was going to restart with Ms. Anderson, and I don't know for sure if that's happened, but the specific sexual assault counseling was done. That was completed. And the allegations that were disclosures that were made are the same disclosures that have been being made. They're not new ones because there's been no new contact. These are the same disclosures that came all about at the same time. And if the court has had an opportunity to review my report in the sexual assault protection order that was original, there were some concerns there. My recommendation for the psychosexual evaluation was to help answer that question. Did this happen or did it not? And that's kind of where I think that this whole case rests. Ms. Rosen has given us an opportunity to have a very structured setting where this child can be reunited with their father, and we will have an opportunity to evaluate that contact, how that child responds, what she says to her personal counselor, how she responds in the visits, as well as moving forward. I don't have any objection to doing the psychosexual evaluation. It is very costly, and I understand that. I don't know whether the court wants to consider that or not consider that. I had a different recollection of what happened in court, so I still think that that's not a bad idea. I think that that's a way of answering the question, but I think that we still need to move forward. I think there has to be some contact. In the original sexual assault protection order, I had recommended supervised visits, and then there was a second criminal investigation started and allegations made for that second or third disclosure, whichever one that was. They were all the same type of information. So I did recommend that at the time. I do think it's safe to move forward. I think it's a very structured setting, and I think it can help answer some of those questions.
Thank you. I guess any other questions for Ms. Day from either counsel?
No, Your Honor.
No, I don't have any other questions. I would note that Ms. Rosen's report talks about or asks the court for recommendations on payment of their fees. I think the indication was that they had incurred 3 hours. I don't know, maybe Ms. Day knows, I don't know what their hourly rate is. And that wasn't disclosed in the report that I had received. So I don't know what 3 hours means or what the anticipated costs are for this moving forward. So
I'm not aware of the hourly fee. I do know that what Ms. Rosen had indicated is generally those costs are dedicated by the court in a specific manner, meaning they're split 50-50 or 60-40 in some fashion, depending on what's happening in the family court. I don't know the hourly rate, but I can certainly get that information and share that with the parties right away.
Okay.
I think the parties' proportional share generally is close to 50-50 or 55-45, something to that effect. So we would just ask that they be shared equally, the costs.
And I guess our position would be that we're here because of Mr. Brown's behavior. And it's Mr. Brown who has put us in a position of having to be in therapeutic counseling and the potential for supervised visitation. He should bear that cost, particularly in light of the fact that he is not current in child support.
And Your Honor, all of those allegations have been unfounded by CJAC, by 2 CPS investigations, and nothing in the criminal investigation. And so at this point, I would ask that it be 50-50. If down the road something changes or the result of this is because it's Mr. Brown's fault or it's because of Ms. Teeler making this stuff up or coaching this child, then we can readdress that at final orders. But at this point, I think it's 50-50. The cost should not be an impediment to having this move forward. I think that's what's trying to happen here. My client certainly doesn't have the money. He's a teacher for children of special needs, and that shouldn't be a factor in preventing him from being able to have reunification with his daughter. And so we would ask that it just be shared equally at this point, and there can be a reservation for final determination at the end of the day.
Okay, so here's to get this issue out of the way. At this point, I'm going to still reserve on any psychosexual evaluation. I think that's something that Ms. Anderson and Ms. Rosen, if they see something, if they hear something, or if they're concerned about something, I'm assuming they would let the court know, and that can be readdressed at any point in time if they have a suggestion, frankly, for any of the parties to get any, seek out any additional information. I'd want to hear that. That doesn't mean I'm ordering it, but I'd want to hear that. I think we need to be relatively transparent in this process. These are pretty significant allegations. And frankly, with a child this young, I don't fault anyone for reacting strongly to these situations, but we also have to be a little bit measured here. So I do think in reviewing the plan, I think Ms. Anderson is and please correct me if I'm wrong, but Ms. Anderson was the counselor that was appointed as part of the CJAC process, correct? So yes, she's been working with the child and is going to continue to be a support, kind of a separate and distinct from what Miss Rosen's going to do as part of any reunification. That does seem to be a very safe space. Miss Rosen's been doing work in this community for an extended period of time. I've referred my own clients to her when I was an attorney. I have no reason to doubt that she would keep the child as safe as possible and frankly stop anything that would potentially be harmful to this child's best interest. So I think her plan does seem appropriate. It does appear to, she's already met with both parties and the child. It seems, well, maybe she hasn't met with the child, but Ms. Anderson obviously has. Right. She's met with both parents and reviewed all the paperwork. And given her experience, it seems like a very thorough and safe approach. So I will adopt that with the caveat that at any point in time, if either Miss Anderson or Miss Rosen feel that this is no longer in the best interest of the child, they'd be allowed to say that, and a motion is brought immediately before the court by, frankly, any of the parties. So whether that be Miss Day, Miss McLean, Miss Poplawski, which with whatever the concern is.
So typically in my experience on reunification, if they historically, in cases that I've had, if the evaluator determines that it's not going well, they will stop and ask the court for more guidance. Is that still in line with what you just indicated?
Fine. Yes.
Okay.
I'd rather there be a stop and then have to come to court to move forward than I think, frankly, I think everybody sitting here that is dealing with this case, the last thing they want is for any additional trauma, harm to come to this little child. So the safest approach, and I defer to the counselors that are going to be working with the family and the child.
Your Honor, can you just speak to giving a time frame of when the initial 2 to 3 visits, 2 to 3 sessions with the child prior to the visits need to happen by? Last thing I want to see is this being put out like 2 months for those 2 to 3 visits. I think the guardian ad litem may have made a recommendation that should happen fairly quickly before the end of the month. So then the actual visits can probably start at the beginning of November. I think that should give it time.
I would agree that it should happen as quickly as possible. Obviously, I don't want to, and by saying that, I don't mean that the child has to have 3 sessions in 1 week just to push it through. I think, as long as it's reasonable and kind of in line with the counseling that she's been receiving with Miss Anderson, to get those started so the reunification portion can get started. And frankly, if there's any concerns that Miss Anderson has in those 2 to 3 sessions, that maybe we need 4 sessions, that we get it started so the reunification portion hopefully isn't pushed back. But I don't want it to necessarily be child-led, but I want it to be counselor-led because I think we need to be very cautious. But I would agree with Ms. Poplawski. I don't want this. I don't want those 3 sessions to take the remainder of the year. I think we need to kind of, I don't know if they're seeing each other once a week, if they're seeing each other every 10 days. I don't know how often. I'm not suggesting that we completely expedite that, but I think those need to be set up and regularly kept so we can move forward.
So, Your Honor, I'd like to ask a clarifying question just for my own, and so that I understand how to help move forward. Miss Anderson is the therapist the child saw through the CJAC sexual assault program. The child regularly sees Celia Delaney at the tribe, and then she would begin these therapeutic visits with Miss Rosen. And I guess my concern is that we have a lot of cooks in the kitchen, and like a little direction on how you would like that to be handled.
Sorry, I think I've been referring to Miss Anderson as her regular counselor instead of Miss Delaney, and I apologize. So,
but just so the court is aware, Ms. Anderson
was the CJAC.
But she's still seeing her privately now. That's my understanding. I'm assuming.
Oh. So that was not my understanding. So maybe we need to find that out.
So perhaps I could, if the court will allow Ms. Teeters to come on with her video and explain. My understanding was that once the once the sexual assault grant was up, that Ms. Anderson had rolled her into a private counseling patient.
Yes.
Tabor, is that correct?
Yes, that is correct.
And how often does she see Ms. Anderson?
Every 2 weeks.
Yeah. And
so she's still seeing Celia Delaney as well?
That's correct.
So, Your Honor, I would just ask that it be Ms. Anderson. I think she might be in a better position than, since she did the CJAC, she's familiar with these sort of processes. And as reunification goes, that might be a better situation. I know that my client also had raised a concern. I believe that Ms. Delaney is the same counselor for Ms. Teethers. I could be wrong, but
she's not. That's incorrect.
Okay, so I know that there was a counselor that she was seeing as well as that the child was seeing. I just want to make sure that if we can get a little more removed from that, that make a little bit more sense.
They do not see the same counselor.
Okay. Mom and child.
Mom and child do not see the same counselor.
I think
we submitted a report for mother previously. I don't remember her name, but
I think I'm going to side with Ms. Poplowski on this. Not that Ms. McLean necessarily disagreed, but Ms. Anderson, and I believe Ms. Anderson has a working relationship with Ms. Rosen. So I guess given her perspective and frankly, she's directly on point to why we're in this situation as far as like the information. So I guess we'll keep her as the kind of point person for those 2 to 3 sessions. And then as soon as she's cleared, then we start the sessions with Ms. Rosen.
And the expectation, though, is that she would continue her private counseling so that the child has a backdrop, an advocate for her through this process.
If Miss Delaney, I don't have it. Yeah, I would never say a child can't see.
Oh, no, I meant Ms. Anderson, that Ms. Anderson would continue.
Yes, sure. Yes.
Okay.
Yes.
And I think that makes good sense, but I don't want it to be additional counselors as well. I think Ms. Delaney's done a great job. I have no fault with Ms. Delaney, but if it's going to be Ms. Anderson as the point person, I'd like it to transition be that, so that we don't have all this different input coming in. It just gets very confusing and conflicting for this child.
No, I would agree. And that's not to say that she can't see Ms. Delaney, but I think as far as what we're trying to do is concerned, Ms. Anderson will be our point person, and we'll go that route. And I did review the financials. I think we're at 5347 with Mr. 53 and I shouldn't say Mr. with the respondent at 53 and petitioner at 47. In this situation, taking into consideration a few different things, I'm going to set it at 40% petitioner, 60% respondent. And then
and that's
obviously additional fees or concerns or issues that may arise that may impact those fees can be reserved for a final orders and trial.
So this is specifically related to the reunification counseling.
Correct.
And
Ms. Anderson and
the child's counseling with Ms. Anderson. Okay.
So that's 60% father, 40% for mother. Did I understand that correctly?
Correct. And then that takes us to the restraining order. I believe that's the other issue, the only other issue that was on today.
Yes.
And I thank you for your memorandum of authorities. Both parties did sorry about the hammering next door here. We're in a state of flux here. So I don't know if you can hear that, but I apologize.
I can.
If you can. Okay, good.
Your Honor, on the restraining order, I would object to the late filing of the declaration on behalf of Teresa. I think that's how you say her name, Teresa Murphy. My client has had no opportunity to respond to that under the court rules. It exceeds the reply page lengths when you consider Mr. Brown's declaration as well as Ms. Murphy's declaration. And Ms. Murphy's declaration is based solely on hearsay. So I'm asking that the court not consider that declaration.
You know, I would just ask then that this be moved over. I think that this is an important part of this this situation. It was brought up that there was no information to provide where Mr. Brown is getting the information from, who's disclosing this, how this came about. We finally were able to have this person step forward, even though they felt uncomfortable about this and fear of retaliation, to provide the declaration. It's also in reference to and part of our memorandum. If Ms. Teethers feels she needs to have some sort of response to that declaration, then I'd ask to move this over. But this is the first time hearing that this is being requested to be stricken. And so I think that it's an important part. I think the court has already reviewed all the documentation, has reviewed the memorandum, and the memorandum also incorporates a discussion of that in the case law that's been provided.
And again, the declaration is based solely on hearsay. It's not first person. The declaration herself says that she was talked to by another unidentified person at the Longview School District in the district office.
I think that the declarant, Your Honor, can talk about what has been happening to her and why she approached Mr. Brown and why she had concerns and what type of information she was concerned about and what she had to do with that information. And it goes directly to why my client is concerned for the safety of his job and why he's asked for restraints to be provided. And as the court is aware by the brief, and without going into complete detail, because I know the court has already read it ad nauseum, both briefings, this court can make decisions relative to any sort of restraints, whether they're full-on restraining orders, whether restraints within this family law action that are tailored to prevent any sort of a situation arising that my client's job is in jeopardy, that information is being spread or discussed or talked about, even if it's something that says these court proceedings are not going to be discussed with anyone, they're not going to be talked, and there is going to be reference to other outside individuals that don't need to be, other than government agencies or other than the police or other than CPS. And so this court can obviously make those decisions. And my client also has stated himself about the fear for his job and what's been referenced to him relative to things being said that would come from nowhere other than these court proceedings.
So in counsel speaking in response to my objection, there is absolutely no argument that there is an exception to the hearsay rule as outlined in that declaration. And what she's asking this court to do is to take face value the factual statements that are outlined in there that are from another unidentified third party, which is clear hearsay upon hearsay. There's been no argument for that would allow the admission of this hearsay evidence, and we're asking that the court not consider it.
So, and I'm assuming you're objecting to a continuance at this point?
Well, I mean, if the I don't think that we need a continuance if the court's not going to consider it. If the court's going to consider it, then I guess my objection would be as to the fact that this has come in so late that we should be entitled to some fees.
Your Honor, I would also ask that the court inquire into the guardian ad litem on her investigation. I think the guardian ad litem has some information relative to what her understanding is happening as well regarding these proceedings and things being said. I mean, this is pretty significant when the whole issue with this.
Okay, hold on. Here's the thing. I don't see this declaration as putting those words coming out of Ms. Teeter's mouth. So I would agree with Ms. McLean that it's hearsay that doesn't get us any closer to the goal line than the initial allegations. I don't know. I mean, I guess if Ms. Day has specific knowledge about Ms. Teeters specifically herself making accusations and spreading those around, I'm assuming Ms. McLean would want to know that as well, and would want to know about it before Ms. Day just says it here in open court. I guess so. Very carefully, Ms. Day, I'm going to ask if you have any firsthand information about the concerns, and I'm assuming you understand the restraining order request that was made by Mr. Brown. If you have any firsthand information that would be beneficial for Ms. McLean and Ms. Poplawski to know before we move forward on this issue.
I don't have any firsthand information about that. I have done some investigation on that as it relates to other issues, and that was some of the discussion in that. So I don't have anything firsthand. My only input about this that I would share is that it's for my position to the court is to remember this is a very young child, and this is information, if it is being shared, that could impact her later on down the road. And that's my only concern about this so far. If I come across direct information like that, I would make sure both attorneys knew that right away, whether we were coming to court or not.
Okay. Based on that, Ms. McLean, I don't know, do you want any opportunity to speak further with Ms. Day about that topic?
No.
Okay.
I would just ask if Ms. Day spoke with Holly Budge directly.
Yes, I did.
I would just ask to explain what the conversation was.
Well, Your Honor, I guess at this point, again, we're talking about constitutional ramifications as it relates to restraining my client's free speech. This is not trial by ambush or a motion by ambush. My client's entitled under the local rules to have all of the evidence set forth supporting the motion to allow her a competent opportunity to respond to the motion and the factual allegations that are being lodged against her. If counsel has talked to Ms. Budge, then Ms. Budge could have submitted a declaration, but they made the tactical decision not to do that. And an effort to try and obtain information third hand through Ms. Day's guardian ad litem investigation is simply inappropriate at this juncture. Ms. Day has not issued a report that my client has had an opportunity to review or respond to. And I just see this as red herrings all over the place, to be quite honest.
You know, we're just asking to protect not just my client, but
I
also
understand what you're wanting to do. So here's where I'm at. I'm a little bit torn on this decision. I think that I understand the case law that was provided by both parties. I understand that an order could be crafted to very specifically prohibit free speech, what would otherwise be considered free speech, based on certain concerns and findings. I mean, we all know that we have a right to free speech. We also know we can't yell fire in a theater. There are a lot of concerns in this case. However, we're unfortunately in a situation right now where anybody at the Longview School District, anybody at the Kelso School District could be watching what's happening right now. We don't know, I don't have anything that says it's Ms. Teeters that's saying these things. So at this point, I'm leaning towards the denying the request for the restraining order. I understand Mr. Brown's position. I frankly think Ms. Teeters would be foolish to speak about this outside of official investigations. Speaking from my criminal background, speaking from just my position, my hope is that she doesn't do that. I do agree with Ms. Day that it would be, I think the more information that is out there in the general public, the more detrimental it is to this child as the child grows. So I would greatly hope that she's not doing this. I clearly don't, if Mr. Brown loses his job and these are unfounded, which so far they are unfounded and continue to be unfounded, then that doesn't help anybody in this situation. So I'm concerned in general. But I'm also concerned because it sounds as though the respondent believes that they have more information that hasn't been presented to the court. So, and I don't know Ms. Murphy's declaration. I did review it. Frankly, I was kind of with Ms. McLean on this. It didn't really enlighten me too much because it basically sounded like, coffee room gossip. It didn't indicate that it was Ms. Teeters that was the origin of these rumors or allegations. So, but I'm also concerned because if there's, I guess, Ms. Poplawski, do you believe that there's more information that could be provided to the court that directly ties Ms. Teeters to these statements?
I think the concern is, and I think it's touched about a little bit, Ms. Murphy, is the fear of retaliation for people to be signing their name to something. And so with the guardian ad litem having spoken to individuals as part of an investigation, bringing information that only really only would be coming from these proceedings and the knowledge, intimate knowledge of what's been going on with the CPS, with the police investigation, and those sorts of things. And my client is simply just trying to get some restraints to stop it, just to stop this before it damages his reputation in his profession, in the community, and just snowballs and spirals out of control. And I think part of even the memorandum was saying this stuff can be narrowly tailored. I mean, and often we see where it says neither party is going to be discussing these proceedings unless it's part of an active investigation, that they're not going to be doing this with third parties. I think that in and of itself could help put a halt to some of this. I think that there's a fear for a lot of people to come forward. They have their jobs as well. And then they're saying information, putting their name to in a court file. Now they feel they're at risk. And that was pretty obvious from Ms. Murphy's declaration. So yes, I think that there are people, but it's extremely difficult to be getting people to come forward relative to this.
So I think the short answer to Your Honor's question is that no, she doesn't have any factual evidence that suggests that my client is engaging in behavior that they're trying to tag her with. Again, as you indicated, and I think I argued this at the last hearing, this is currently being watched by who knows, and who knows how many people. So that is I'm sorry.
57 people are watching right now.
I'm sorry?
57 people are currently watching this hearing.
Okay. I don't have access
who those folks are, I don't know.
So yeah, I don't know who they are. They could be Kelso. I mean, counsel and I believe to some extent Ms. Day have openly talked about the CPS investigations, the allegations, the information that is part of this. But there has been nothing to suggest, and my client has submitted a declaration to you that outlined all of the legitimate people that she has talked to relative to this, which includes the child's school and daycare providers, in order to effect the original sexual assault protection order and now the restraining order that are currently in place, so that those can be lawfully enforced if they need to be. There isn't one shred of evidence that my client has done anything to harass, molest, disturb Mr. Brown's peace. She is a mother who's trying to protect her child.
Ms. Poplawski, anything else?
No, Your Honor, my client is just trying to protect his job and his reputation. And again, allegations that have been unfounded by every single independent professional person who has taken a look at this. And it just isn't stopping for him.
Okay. There were a few things that were submitted that I kind of made mental note of that I think do really hold weight to how I'm going to rule in this case. And I think one of the things is we have the Kelso superintendent that is aware of the allegations, has made an unfounded finding of anything that's going to directly relate to Mr. Brown's position. Mr. Brown, obviously, I don't know that is I guess a letter that indicates, hey, you're always going to have a job here. So, and I understand his position there, but it clearly is something that there's no new allegations. The allegations are out there, and you still have a job. So there's that. Additionally, in one of Mr. Brown's declarations, he indicated that this isn't the first time that it has happened, that he's already had to go through and address this before in the same job that he's in now. So, and that those were unfounded and that there were no issues there. So this is, if I take those two statements from Mr. Brown, isn't the first time this has happened. Everybody knows about each time this has happened, and they've both been considered unfounded by my job. Clearly, does that mean if a parent that's currently got a child that he interacts with, or someone gets information about this, that couldn't have raised concern in that individual, and then they move forward and do something? No, it doesn't mean that, but it also means that the school's made a determination at this point, where they're at with these allegations. And I think we all are aware, at least at the time, where we are with these allegations. We do have a parenting plan that's in place, and it indicates, at least under the section 14, communication with the child, that neither parent shall advise the child of the status of the child support, legal matters, anything regarding the relationship, share, or allow the child to access any part of the GAL report, different declarations, use the child directly and directly to gather information about the other parent, or take verbal messages to the other parent, make derogatory comments about the other parent, or allow anyone else to do the same in the child's presence. Neither parent shall allow or encourage the child to make derogatory comments about the other parent. What I'd like to do is enter maybe an additional order or an amendment to the parenting plan that the parents will not discuss these allegations outside of official investigations through any authorized parties, whether that be DCYF, law enforcement, their own employers, or the counselors that are dealing with these allegations and they're moving forward with. So I'd like that to be part of the parenting plan and not as a restraining order. I think we're in a position now where Ms. Day said it best. We are where we are, but we need to move forward. Rehashing this, and again, I'm not claiming that I'm not taking sides as far as it's happened or it hasn't happened. But I think we need to move forward and consider the best interest of the child, and ongoing rumors about certain allegations aren't going to be in the best interest of that child. This is a school-age child. This is a public hearing. These are public records. They're accessible to pretty much anyone who wants them. So we have to be very considerate, I think, of that. So I would assume that might fit best in section 16, just kind of as an addendum that moving forward.
You mean in section 14?
We can do it in 14 as long as it's not under the communication with the child. But yeah, 14 works.
Okay. And have you already put together language?
No.
Oh, okay.
I can.
Would Your Honor please put together what language you deem to be constitutionally appropriate, even though it's not a restraining order, but that you would like to have included? And then I think I did the last parenting plan. I can just plug that in as an amended parenting plan and submit that to counsel and Ms. Day for signature.
That would be fine, Your Honor. I think otherwise counsel and I will end up disagreeing. So I think if the court just kind of issues some language, that would be the best.
I will, how about I just do a bench order adding essentially another section for 14 to the parenting plan, temporary parenting plan. And then I will scan it and email it and file it, and I'll include you, Ms. Day, as well.
Your Honor, do you want me to can you just include in that order that number 162 will be put under seal, or do you want a completely separate order, or would that be appropriate just to put it in that same order since you're going to be issuing a separate bench order?
I think we're going to need to have another order no matter what, because the court's reserved as it relates to the psychosex eval. You've provided specific parameters as it relates to the reunification counseling. So I think we're going to need to follow up with an order in general.
That's fine.
When are you looking at potential presentation date, Your Honor? Did you indicate the next one available is the 31st?
Yes, unless we want to do a Friday at 8:45.
Your Honor, I'm not available on the 31st. And I would also just ask that this not be a delay to get the counseling sessions started. What I could see is by the time we get the presentment, then we're going to start working on getting the child into these sessions, and it really is going to take to the end of the year. So I just want to make sure that the presentment date doesn't create a longer delay.
I would hope that wouldn't.
I don't think that. Yeah.
I would hope that wouldn't. So I would ask the parties to move forward on those scheduled meetings, and I'm assuming Ms. Day, that Ms. Teeters and Mr. Brown received a copy of that recommendation letter from Ms. Rosen. Okay. So
yes, when I reach out to everybody, I'll send that information out so that's everybody knows how to move forward.
So yeah, I appreciate this, that Ms. Poplawski. So I would ask that start now and not start at the entry of the orders. If you're not here on the 31st, let me see here. I have Friday the 20th, Friday the 3rd, or we can go all the way to October 7th, or excuse me, November 7th.
I think November 7 would work much better for me if council works for you.
That's fine. November 7 at 1 o'clock, Your Honor.
Yes.
Okay. Your Honor, I would ask to be excused from that presentation. I have trials back to back for the last 2 weeks and the first 2 weeks of November. So I will sign off.
And do we want to set it to review progress, or do we want to just have that noted up if there's any concerns with that?
I would just assume we note it up, just because we don't know what their timeline is going to be as far as how the child responds to that process. And I'm assuming that Ms. Day and at least Ms. Day will keep us updated on any contacts that she receives. So,
yes, ma'am.
Thank you.
Thank you, Your Honor.
I anticipate I just need to get a bench order, and then I'll fill that out. I will scan it to you. So I'm going to scan it to you before it's filed, just so you won't be have the stamps and everything on it. But I just want you to know what the language is right away. It's going to be along the lines of the parties shall not discuss the allegations of their child in common with anyone outside of official investigators, and I'll list law enforcement, DCYF, the counselors, and their counselors until further order of the court.
So do you mean specifically with regards to the allegations? Because I mean, that language in and of itself would mean that my client wouldn't be able to talk to the grandmother about her granddaughter.
I'm assuming she's already told her what the allegations are. Why does she need to continue having conversations specifically about the allegations? She can talk about her counseling update. You didn't say that.
No. You said that nobody was allowed to talk about the child to anybody.
No, the allegations of the child in common.
Okay.
The allegations that were made. I'm assuming that family members are already aware of what we're dealing with. That cat's out of the bag there. But further discussion of that. That doesn't mean that, hey, child's doing super great in their counseling with Miss Anderson. I don't think anybody has a problem with that. But we don't need to rehash the allegations with anyone outside of any official investigators, and I'll list those and the counselors. So and I'll make sure to include if Mr. Brown has a private counselor, obviously he can discuss what he wants to do with his private counselor. Ms. Teeters with her private counselor, they would be included in any discussions. And
I'm assuming the guardian ad litem are respective attorneys and
Your Honor, I'm not sure, but there isn't a restraining order. I just want to make sure by this process for the visitation, my client isn't violating the restraining order. So some sort of language that we can do, or do we have to amend that separately? That this is modified to the extent regarding the reunification visitation or something. I just don't want to have an issue with my client relative to that.
Is there a copy of that filed in this cause number? Do you know, Ms. McLean, or is there other cause number?
Yes, there is a restraining order in this case. It is the temporary restraining order was filed on May 23. It's clerk's paper number 36.
Thank you.
You're welcome.
I thank you for raising that, Ms. Poplawski. I highly doubt, I guess, that anyone would, his participation in this court-ordered reunification, hopefully that wouldn't result in a contempt motion or something of that nature, but I don't know if, let's see, this specifically says.
I don't see that engaging in therapeutic counseling would be a violation of that because it's not the child's school or daycare. Or my client's home, vehicle, workplace, or school.
If it says, I don't have it directly in front of me, but if it says no contact, then I just.
It does not. The temporary parenting plan is the one that provides for no contact.
Temporary restraining order is do not disturb the protected person or child, do not go into the grounds of that protected person's home, workplace, vehicle, school, or daycare of the child, and not knowingly stay within 500 feet of the home, vehicle, workplace, school, or daycare of the child. So,
and not to assault, harass, stalk, molest.
Right. And then the parenting plan temporary under 4A does indicate no contact to be reviewed after conclusion of investigation. So what I'll do is I'll include in the order amending kind of an addendum to the temporary parenting plan that contact with the child is allowed based on the court's ruling on October 10th, 2023, and the suggestion of reunification therapy as outlined by Charlotte Rosen, and I'll just refer to her letter. So so that's clear as well.
That contact with the child is allowed through the reunification therapy?
Yes.
Okay.
So I'll do those, Ms. Popovsky, both in one bench order as an addendum to the temporary parenting plan. So that hopefully should insulate Mr. Brown from any concerns there.
Is the court, so the court's denied the restraining order. My client has made a request for attorney's fees as well as the immunity request under RCW, what is it, 4 something?
And Your Honor, I think we already addressed the immunity section in our briefing, and that I don't believe that she's met her burden relative to that, because my client never indicated that any of the requests were relative to information provided to the police, to CPS, or in that respect at all. I think it was relative to things that were happening within his job. So I don't think that that falls under the immunity provision. And so we'd ask that you deny the fees.
I did review everything with relation to that. I did, and I appreciate again that both parties did provide some case law regarding the request for fees. Frankly, this is a situation where I think both parties reacted strongly to the allegations in different ways. I'm not going to make a finding that the $10,000 fee is appropriate in this case, so I'll deny that request. There was a request for an attorney's fees from Ms. McLean as well, and I think it was $1,500 that you were requesting?
The original request was for $1,500 on the ex parte, and then with the memorandum and everything, my second order that I submitted asked for $2,500.
Okay. And
you know, I don't believe Ms. McLean was in the ex. She didn't expend any time in ex parte.
When we were here for what I meant, when we were here for the first hearing on the ex parte order, which was what, 2 weeks ago? 3 weeks ago?
And I believe, Your Honor, we said everything over. We were here relative to my client's motion for temporary orders as well. So that was part of the hearing, which she had to be at anyway. And so everything was then reset because the court wanted more information regarding the reunification counselor. So it wasn't any additional time or any additional effort on that part.
at this point, I'm not going to award any attorney's fees either. I think this is a bit of a quagmire, and I appreciate both parties' positions, but I'm not going to award any attorney's fees.
All right, thank you.
All right, good luck, everyone. Thank you.